Okay, hello everyone, and thank you so much for joining us this afternoon. My name is Nina Holatova, and I am a lawyer and program coordinator at the Community Legal Education Association, also known as CLEA. For those of you who aren't familiar with what we do at CLEA, we are a not-for-profit charitable organization, and our mission statement is unknown rights are not rights at all. We've been working to improve access to justice by providing education, information, and other resources to Manitobans about their rights and the law. And we've been doing this since 1984. So this means that we are very much looking forward to celebrating CLEA's 40th anniversary next year. We offer webinars every spring and fall on a variety of topics. And today's topic is family law, collaborative practice, mediation, and alternative dispute resolution. Just a couple of pieces of housekeeping. Today's presentation is being offered in webinar format, which means that everyone is muted and cameras are off by default. We will have a dedicated time for some questions at the end, but feel free to send your questions in during the course of the presentation by using the Q&A function. However, if you do have a more specific question that pertains to your particular legal situation, I encourage you to reach out to our law phone-in program to speak with one of CLEA's lawyers for free. With that being said, I would now like to introduce our presenter, Norm Yusim. With over 4 decades of experience, Norm is one of Manitoba's most prominent practitioners of family law. He guides clients through all aspects of family transition, including separation and divorce, custody matters, child and spousal support, and property accountings and division. Norm is qualified to resolve settlements through a collaborative law process. He is also experienced in family law litigation in a courtroom setting and a variety of arbitration and alternative dispute resolution practices. Norm has been trained in mediation and has completed the National Family Law Arbitration course. He can conduct both mediations and arbitrations. Norm also sat on the Law Society of Manitoba President's Special Committee on regulating legal entities, and he is on the board of the Family Arbitration and Mediation Institute, Inc., which is an association of lawyers and other professionals dedicated to helping individuals and families resolve their family law disputes outside the court system through mediation or arbitration. With that being said, we are so pleased to have him here today, and without any further ado, I will pass it over to Norm.
Thank you, Nina, for inviting me and for those very kind comments. I am speaking today about the processes to resolve matters in family law, including collaborative practice, mediation. I'm going to include arbitration, negotiation, and other alternate dispute resolution processes. I don't know if they're alternate dispute resolution processes anymore, as they are just another process in trying to resolve matters in addition to court. You've heard often that court is the last place of last resort. It really is the last place anyone ever wants to be. Court is damaging. I'll discuss today the processes available in family matters for resolution. An effective advocate has many tools in their toolbox, and the toolbox is filled by training. The training is necessary, time-consuming, but worth it. I also want to predicate my comments and presentation today with the need for lawyers, coaches, and arbitrators to do violence screening. Since March 2021, when the Divorce Act of Canada was amended, we as lawyers are required, pursuant to the Divorce Act, to do violence screening, which I feel should be done at the earliest opportunity and at the commencement of the file. We as lawyers and other professionals, coaches, mediators, and arbitrators must know if there is family violence or a significant power imbalance. We are also, as lawyers, required to screen for family violence and take courses to be able to competently comply with our statutory obligations. We must not only identify it, but also manage the family violence and the issues arising from it in any of our processes. There are a number of processes that are utilized to resolve conflicts outside of court, known as alternative dispute resolution, or ADR. The processes I'll discuss today are negotiation, or form of negotiation, collaborative law or cooperative law resolution, mediation, arbitration, as well as JDR or Judicial Assisted Dispute Resolution. What do these processes mean? Well, collaborative law is a form of negotiation in which the separating couple and their lawyers commit to resolving all of their practical issues arising from their separation without litigating through a court. Collaborative law is a form of negotiation, exchange of advice, and discussions that all take place in four-way meetings involving the couple, their lawyers, and often their coaches, so that there is a complete transparency about the legal advice being given. When I started doing collaborative law approximately 22 years ago, the lawyers trained and met with the clients to try and resolve with four-way meetings. As time has progressed, it is the experience now in Manitoba to have coaches present during the collaborative law meetings, as they're very important in the meetings to assist the parties with communication and the lawyers as well. The commitment of all four people and the coaches is reinforced by their agreement that if the negotiations break down, the couples have to use different lawyers if they wish to utilize litigation to resolve their issues. Stu Webb, in or about 1990, was the one who started collaborative law because he had it with going to court and the lack of consistency and predictability of going to court. The collaborative law process is interest-based negotiation where the best interest of the family is central to any resolution of the separation matters between the parties. The parties retain the control over the process and the control over their agreement. The parties enter into a collaborative participation agreement prior to the commencement of the process. In addition to the full team, including the parties' lawyers and coaches, the parties will often meet with their coaches to resolve the parenting issues between them without the lawyers present, including negotiating a parenting plan, having regard to the best interests of the children. Another process that is utilized is called the cooperative process, which I'll discuss in more detail later. But the essential difference is that with collaborative law, the lawyers agree that they'll withdraw if the process does not proceed, whereas with cooperative law, the parties use the interest-based negotiation, but there's nothing preventing the lawyers from continuing to act for the parties if the matter proceeds to litigation, or if litigation is necessarily required to be commenced during the course of the cooperative process. Another process I'll discuss is mediation. Mediation is a process in which an independent third party, as a mediator, to assist a couple to resolve all of their practical issues arising from their separation. The mediator is a neutral party, often a lawyer, who provides information but not advice to help the parties come to a resolution of their issues. The outcome of the mediation is a settlement proposal, which the couple is encouraged to take legal advice from their lawyers before any such proposals become binding. The mediator plays an active role in assisting the parties in identifying their needs and their interests. It's important that the mediator remain impartial at all times, and they cannot favor one party over the other. As well, the mediator cannot provide an opinion on who is right and who is wrong. Instead, the role of the mediator is to help one person speak with the other person to reach a satisfactory solution. The next process, arbitration, is a form of private dispute resolution and adjudication taking the place of the court process and conducted in private. The arbitration process is flexible and is adapted to the needs of the parties. The arbitrator's jurisdiction arises from the arbitration agreement, which is signed by the parties and the mediator. And the mediator makes a binding decision about any questions that the couples and their advisors put to the arbitrator. The arbitrator's award is then made into a court order. There have been recent amendments to the Arbitration Act of Manitoba that allow for arbitrations in family cases. That was not always the case. It is routine in Ontario, for instance, to have arbitrations in family matters, and it is now becoming more prevalent with the passing of the legislation and the new provisions relating to arbitration in family law cases. Now, arbitration is similar to a trial in that the person or the arbitrator rules upon the case and decides who is entitled to what. However, arbitration is different from a trial conducted in court in several ways. It is private and confidential, unlike a trial which is open to the public. When parties who are in conflict and accept to go to arbitration, they generally lose the right to go to court for the same dispute. It's generally the parties involved in the dispute who choose and pay for the arbitrator. The arbitrator is a specialist in family law, generally, and the parties involved in conflict can choose some of the rules the arbitrator must apply. They can even give the arbitrator the right to ignore certain legal rules. Parties enter into an arbitration agreement with the arbitrator, which limits or provides a wide range of powers for the arbitrator. And the arbitrator can only act within the confines of the agreement the parties execute. I'm now going to discuss a little more about collaborative law and the process. The parties, as I stated, enter into a collaborative participation agreement, which is signed by the parties and the lawyers and the coaches, which includes some of the following terms. The parties fully and honestly have to disclose information and documentation, including financial records, and have to agree to not pursue litigation. There are a series of four-way meetings that take place with the parties, their lawyers, and the other professionals, such as financial advisors, child care specialists, and the coaches. I've been involved in collaborative law meetings where evaluators and appraisers have attended the meetings to provide opinions and explanations with respect to the valuation of shares and businesses and to help determine incomes of the parties. In between meetings, the parties meet with their lawyers to discuss their next steps. A separation agreement is drafted and signed by with all the terms that have been agreed to by the parties. And if no agreement is reached, all parties agree to start again with other lawyers before going to court. The parties do not start over completely, as the agreement provides for the parties allowing to use the financial disclosure, for instance, if they proceed to court, that they receive during the collaborative law process. The parties agree to act in good faith and to respect each other. There'll be no threats to withdraw during the process. They agree to, nor do they threaten to go to court to try and achieve a desired outcome. The parties agree that the children's best interests are their priority, and they will not discuss settlement issues with their children. The parties agree to utilize the full professional team and engage their own family professionals if necessary. The parties have the power on the recommendation of their coaches to retain and engage a child specialist. And they also agree that the neutral consultants and appraisals and evaluators will be jointly retained and will be each will be responsible jointly for the consultant's fees. The parties agree to provide all information that may affect any choices and be candid with their disclosure. The parties further agree that anything written and information exchanged during the collaborative law process is confidential and without prejudice. What that means is that it cannot be brought up in court. There are exceptions, as I stated earlier, sworn financial statements, Any expert report or appraisal that the parties and the expert agree will not be confidential and without prejudice. And the parties agree that either of them must provide information that they're obligated to provide at law to report to Child and Family Services if necessary. During the collaborative law process, the parties agree to maintain assets and property, maintain all their existing insurance coverage and beneficiaries, maintain all existing health and dental benefits, refrain from incurring any debt which the other may be held responsible for, maintain beneficiary designations on pensions and RRSPs, and to maintain the joint tenancy on any property. These are all very important acknowledgements by the parties so that they can trust each other when proceeding through the process. The parties acknowledge that the process is voluntary and that also notice of intention to withdraw from the collaborative process will provide and will provide all the parties with the written notice, and that the parties agree to wait 30 days before starting a court proceeding in order to permit both of the parties to retain new lawyers and to make an orderly transition. If, however, there is an emergency that occurs, then the parties are allowed to proceed to court. That is an exception that the parties can agree to in the face of an emergent matter taking place. There are provisions for the mandatory termination of lawyers during the process if there's been a misrepresentation by a client or a client has withheld information. I've had cases where a lawyer has withdrawn from the process and there's no obligation on the lawyer to explain why they're withdrawing from the process, but that has occurred. I've been involved as well where a lawyer has withdrawn from the process and I became the collaborative lawyer on the case and signed on to the agreement to become the collaborative lawyer and to be bound by the terms of the collaborative participation agreement initially signed by the parties. The parties agree as well, and this is very important, that negotiate using the collaborative process is without prejudice to any right of either party to receive ongoing retroactive child or spousal support. This is an important provision because generally the law in Manitoba is that for a party to entitled to spousal support, they have to first file a petition or application in court seeking spousal support. The court generally will not be retroactive prior to the filing of that document. However, the parties agree that under the terms of the collaborative participation agreement, that they can in fact bring an application retroactive to the date they signed the collaborative participation agreement. As well, the parties acknowledge and agree that the lack of written notice or the failure to commence a court proceeding will not be used as a defense for any claim for retroactive support. As well, if legal limitation periods are coming up, there is provision in the collaborative participation agreement to allow one party to file court documents to allow the filing prior to the limitation period expiring. The collaborative law process, when I've been involved in it, has had a very high success rate, and it is sometimes hard slugging, but does in terms of the work that has to be done in it, but it has resulted in many agreements between the parties. With respect to mediation, if it does not work, you do not have to start again and retain new counsel. In collaborative law, knowing that the failure may result in greater expense, it may motivate the parties to try harder to try and resolve the matter. There have been collaborative law cases I've been involved in where the clients have insisted and requested that I be allowed to be their lawyer if the matter proceeds to litigation. There is a philosophical divide on whether or not the collaborative law agreement requiring a lawyer to withdraw if the matter does not resolve is appropriate. But I have entered into agreements with lawyers and the parties, not often, and on a limited basis where both lawyers have been allowed to continue to act if a collaborative agreement is not reached. The benefits of mediation are large as well. One of the difficulties, however, is that lawyers often are not involved, and once an agreement is reached and the clients seek independent legal advice, and they have explained to them the law in relation to their specific issue, it creates the possibility of a renegotiation of some issues. Whereas with collaborative law, the lawyers are present and advice can be given during the course of the collaborative law process. As I stated earlier, the mediator has no power to make binding decisions about the separation or the divorce. It's an informal and flexible approach, and there is no obligation to hire a lawyer. Mediation is less time-consuming than litigation and is relatively inexpensive. As well, some believe mediation encourages creative solutions that may be outside what the law would prescribe, such as making payments for job training now for a shorter amount of time for paying spousal support have been entered into. In mediation, the parties are free to decide exactly what will work for them, regardless of whether or not it is outside the box or not. Mediation does allow the parties to allow professionals to the process, including their lawyer if necessary. I have been involved in mediations where I was not directly involved in the mediation itself, but I was in an anteroom available for my client to seek advice during the course of the mediation if required. Collaborative law, like mediation, is also informal and flexible, as well as less expensive. The lawyers are present to look out for the client's interests. If the divorce involves complex legal or financial issues, the party may want to choose collaborative law over mediation. If one of the parties feels that they are disadvantaged when negotiating with their spouse, that party may benefit from the added structure and insulation of the collaborative law process. Although the parties in both processes are allowed to make agreements that a judge would not be able to make, the parties and lawyers and the mediator should keep in mind that agreements as to child support are subject to the court's review when a divorce is pronounced. Under the Divorce Act, the court has to be satisfied that arrangements relating to the children, financial arrangements being related to the children, are reasonable and are satisfactory. If they are not, the court will not pronounce the divorce until the court is satisfied that the needs of the children have been met. Are there negative aspects to mediation and collaborative law? The biggest downside to the collaborative law process is that, as I stated earlier, is that both lawyers must withdraw. As I indicated, although not completely back at square one, new advisors and experts are necessary to retain, which could add significant expense and delay. As I stated, it is relatively rare in my experience for the collaborative process to completely break down without a chance of success. If mediation is unsuccessful, there may be a tendency on the part of the spouse to give up on reaching a reasonable settlement and possibly having to start over, losing the money spent on the mediation. During the collaborative law process, there have been agreements reached on individual issues without agreements reached on all issues. In the past, when an agreement was reached during a collaborative law meeting, the parties agreed that if they stated that the agreement was one to be relied upon, it would be an agreement for all purposes. However, there have been situations where a misunderstanding occurred. So my collaborative participation agreements now include provisions that any agreement reached between the parties must be reduced to writing and signed by the parties and witnessed by their coaches. That way there can be no misunderstanding as to what was agreed to, and that it makes sense to make individual agreements. And if there are issues still to be resolved that require the intervention of a judge, those issues can be referred to the court, or if the parties decide to through another process, arbitration. In Manitoba, while anyone can mediate, there is a benefit to engaging a mediator who has both experience either practicing family law or other professionals with experience in working with families who separate and divorce. There is a group in Manitoba called Family, FAMLI, which is a group of lawyers who work as mediator arbitrators in Manitoba, and that Family sets educational standards for their affiliated mediators. As I stated earlier, prior to the amendments to the legislation in Manitoba to the Arbitration Act, there was a difficulty with having arbitrations in Manitoba, as there was no method or ability to have an agreement put in the form of a court order without filing a court application. All mediators affiliated with Family have professional and advanced degrees either in law, psychology, social work, or marriage and family therapy. All mediators affiliated have taken not less than 40 hours of mediation training, including 16 hours of advanced family mediation training or equivalent. All mediators affiliated with Family must also complete not fewer than 14 hours of training in assessing for power imbalances and domestic violence or its equivalent. When the parties retain a mediator and an arbitrator, the parties normally share the costs of that mediator whose hourly rate will be comparable to that of most lawyers' hourly rates. When the parties cannot resolve between them their issues, they appoint the neutral, qualified practicing lawyer to make decisions. The person appointed to make decisions is called the arbitrator under the Arbitration Act of Manitoba. When you hire the arbitrator, they are effectively your private judge. So what we have in Manitoba utilizing Family is MedArb. What happens is that the arbitrator is the mediator who tries to narrow the issues from the parties. And if an issue cannot be mediated, then that mediator becomes the arbitrator and it becomes the decider of the issues between the parties. The litigation is both difficult to access quickly through the family court in Manitoba and is a more expensive way to resolve issues. Due to several factors, including its formality, it is not uncommon to experience delays in the court process. In arbitration, the parties can have quick access to a decision maker whose decisions are binding on each party. For example, I've had a situation where parties disputed the parenting time during Christmas. The parties, rather than going to court for an urgent hearing prior to the new amendments to the Queen's Bench rules, retained a mediator or arbitrator to resolve the parenting issue over Christmas. The parties met with the mediator, and after hearing both of them, could not have it resolved, allowed the parties to basically make their case. And within 4 days, a decision was made by the arbitrator, which the parties agreed to be bound to. The arbitrator can make substantive and enforceable decisions the way a judge would in court. The arbitrator's decision or award becomes a court order. It is quicker, private, and usually less expensive than the court process. I've been involved most recently in a mediation arbitration where the parties mediated over a period of 3 days the interim issues, so as to prevent the arbitrator from having to arbitrate those issues. And it brought calm to the storm, so to speak, and the parties were bound by it. Choosing arbitration means that your dispute resolution becomes private, unlike litigation where hearings are open to the public. When using arbitrations, the parties can determine how formal or informal the proceedings will be. For instance, whether there will be transcripts of the proceeding if they proceed to arbitration, and the parties can choose a process with greater autonomy than the court process. Before engaging in arbitration, to make a decision for the parties must obtain legal advice from a lawyer independent of the arbitrator so that each person understands the risks and benefits of engaging in arbitration. As well, as I stated earlier, the violence screening takes place, and the parties will normally share the cost of the arbitrator, whose hourly rate will be comparable to that of most lawyers, as I stated. Why in Manitoba would a party choose a family arbitrator if they cannot resolve their matter through collaborative law, mediation, or negotiation between the lawyers? In Manitoba, only lawyers with at least 10 years of experience, primarily in family law, are permitted to arbitrate family law matters. Family as a group sets a higher standard, and as I stated, all affiliated arbitrators are subject to certain education requirements. The Family Arbitrator Mediation Legal Institute is a new association, and I would recommend that you check out their website to see what it offers. As well, I recommend that you also check out the Collaborative Practice Manitoba website in Manitoba, which describes the collaborative law process, lists the lawyers who are members of the Collaborative Practice Manitoba group, not only lawyers, but also coaches, child specialists, and financial advisors. Why would someone arbitrate using the same person as a mediator? It's a blended process that has several advantages. There's a cost saving by using the same lawyer to facilitate the mediation and then arbitrate any remaining issues if necessary. The mediator arbitrator will have a well-developed understanding of the parties and their children's needs without the parties having to start over with a second professional, which almost always means greater financial expense. And upon using mediation and arbitration, it is a faster process than the traditional court process, and is something to keep in mind. Whether you choose to mediate or arbitrate your family matter, neither the mediator nor the arbitrator can provide legal advice to either party. as the role is required to be neutral and impartial. Lawyers have an important role to play, however, before, during, and after mediation or arbitration. No person can enter into an arbitration process without first obtaining independent legal advice and participating in screening for domestic violence. I have a case now where in the collaborative law process where it was necessary to do a violence screening, and the coach for my client did the violence screening, and I worked with that coach in determining the appropriateness of the collaborative law process and the strategies to use in the face of any family violence that may have occurred. Family therapists and parenting coaches can be invaluable for the parties in navigating their family law matters. Receiving emotional support during this difficult time can help parties make better decisions for themselves and their children. I had one case that comes to mind where the parties were negotiating their matters in the traditional way, and it was resolved. But my client called me and thanked me and told me that the most important thing that I had done for her was referring her to a coach to help her navigate the process. Parenting coaches are qualified therapists who assist parties to work together more cooperatively as co-parents, focusing on skill building in areas such as communication, managing different parenting styles, and making parenting decisions in ways that support children living in two homes. Some professionals can, after meeting with children, present the voice of the child during mediation or arbitration as well. Family therapists or coaches affiliated with family and in the collaborative law process hold professional and advanced degrees in marriage and family therapy, social work, and psychology, and are regulated by their own professional bodies. As part of the team, whether in the collaborative law process, the cooperative process, or in mediation, financial matters on relationship background can be confusing and difficult to navigate without an expert providing financial advice. It is essential to understand the tax issues that can arise when entering into agreements with respect to property, child support, and spousal support. Collaborative law and family maintain a roster of financial professionals that can assist. And although it does not provide a minimum training standards for these professionals, as they are regulated by their own professional bodies. In Manitoba, there's one further process that I'd like to discuss quickly, and that is that there is the Family Dispute Resolution Pilot Project Act, which is part of the Family Law Modernization Act, which was passed by the Manitoba government in June of 2019, which was introduced to create a process outside the traditional court system for resolution of family disputes. It is not in place right now, but participation in the process will be mandatory for people in Winnipeg who have disputes about custody, access, or support under the Family Maintenance Act, which deals with separations, and other Manitoba laws. This has never been done before in Canada. The new process is intended to minimize the number of cases needed to go through the family law court system and to assist the parties in resolving their disputes outside of court. The parties will be required to go through this process instead of making a court application in Winnipeg, and if their family dispute is about parenting arrangements, custody and access or support, when the Family Maintenance Act applies, for instance, when the parties are not divorcing, but rather are separating, and where they're dealing with property under the Family Property Act of Manitoba or another Manitoba law applies. A resolution officer will assist the parties in reaching an agreement. In some cases, the parties will be referred to other services to help them reach agreement about specific issues. If that fails, then the parties will be referred to a designated adjudicator. Proceeding to court will become the last resort for these types of cases. So, in conclusion, there are a number of processes available to the parties in Manitoba, other than court, to assist them to resolve their matters in a less stressful and more cost-effective way, which we, as lawyers and as supporters of clients, should all keep in mind as part of our toolbox in trying to help the parties resolve their outstanding family matters. Thank you.
Thank you so much, Norm, for that presentation. Okay, so we will open up the floor to questions now. If anybody has any questions, you can either put them in the Q&A or use the hand raise function. I do see somebody asking if it would be possible to get the contact information for the coaches. So I will put some links and resources in the chat there. But I believe, I don't know if you can clarify, Norm, but these are coaches that you can find privately just by searching online or through various organizations.
Yeah, if you go through, for instance, go look at Collaborative Practice Manitoba, their website. They have a list of parenting coaches, child specialists, communication experts who have collaborative law training, who will also work with lawyers and with parties and other professionals in a non-collaborative case. Through my experience in collaborative law, I've been able to use what knowledge I've gained in my other cases that are not collaborative. So yes, I would recommend that you look at that that list and word of mouth as well if you wish.
Okay, sometimes we get questions about the collaborative or the cooperative process sort of being used as a stalling tactic. So I'm wondering if you can speak to that a little bit, maybe as far as what lawyers can do to prevent this if things are really dragging along, or what clients can do if they think this is happening.
Yeah, that's a very good question. When I first started practicing collaborative law, I did notice, and it came to my attention, that some people were using it for an improper purpose. They were trying to maybe extract agreement on an issue important to them and then leave the process thereafter. It's our job as a professional to make certain that the process is not being used for an improper purpose and that there's good faith. The parties are undertaking to use the process in good faith. And if I, for instance, recognize that it is being used for an improper purpose, it may be that the party will have to withdraw from the process. But they have the collaborative participation agreement that protects them with respect to limitations and with respect to seeking retroactive support. And with the cooperative process, as I stated, there's nothing preventing, while that process is ensuing, from proceeding to court to try and protect whatever rights you have going forward while you use the cooperative process.
Okay, and I'm also wondering if you can speak a little bit to what the family violence screening process looks like, what clients can sort of expect, and then what steps do the lawyers or mediators or other professionals take to sort of take that into account?
Well, it's I've done quite a few of them, and I have taken 2 separate sets of courses in relation to violence screening, and there are different screening processes available. What I do is I don't rely on just one process. I use the 2 processes together. And what I do as part of it is I interview my clients, asking questions through the screening process. There's a guide that you can use to, there's one guide that rates on a scale the extent of violence on a scale, and what you determine after asking the questions, again, the answers is how best to proceed to protect your client from any potential violence. And in collaborative law, I work very closely with the coaches to make sure that there's no undue any sort of violence or cues going on by one of the parties that could be construed as being harassment and that sort of thing.
And so,
yes.
So go ahead.
Go ahead.
Yeah, I was going to say, so you spoke to family violence a little bit, but I also, some people have also asked about sort of the difference in incomes and how that might affect these sorts of proceedings. So if one person maybe has a very high income, one person doesn't make as much money, the person with the higher income might be able to maybe use these processes to their benefit or to their advantage. So can you speak to that a little bit? Is that something that's common?
Well, my experience is where there's an imbalance, a financial imbalance, I try and work out for the parties a child support payment, a spousal support payment, and not allow one party to sort of lord over the other spouse. The fact that there's no money flowing and money will flow if certain agreements are made. That is not a show of good faith if one party with the resources refuses to pay support, which are obvious obligations now that we have the child support guidelines and the spousal support guidelines. That would bring into question for me whether or not the collaborative process is even an appropriate process. Right. To begin with.
Okay, another question I have here is about judicially assisted dispute resolution. Is this something that's available or commonly used in family matters, or not so much in your experience?
Well, I used it quite often. It's when under the older system, and I've used it under the new system. There's a newer system, and I've addressed that with triage. At a case conference, you can request from a judge their view as to whether or not they think that judicially assisted dispute resolution would be appropriate. What is judicially assisted dispute resolution? What it is really an extended case conference where a judge is appointed by the Associate Chief Justice of the Family Court to work with the parties to try and resolve the case. My experience is that once you have the case conference judge on side, you then write the Associate Chief Justice of the court requesting that the case be allowed to be judicially assisted to be resolved. You have to suggest 3 judges to the Associate Chief Justice, from which she will choose, if she thinks it's appropriate, a judge to mediate through the judicial dispute resolution process. You then, once that judge is appointed, the judge will often meet with the lawyers and discuss the issues and will provide direction as to what they want filed by the lawyers prior to the mediation with the judge taking place. And I have found with complex cases, and with uncomplex cases, with parenting issues, that the judges have been able to resolve the issues satisfactorily. The mediations usually take place for an afternoon or a morning, and I've had them take place all day. I've had them carry on over 2 days. I had one case that was scheduled for trial, and Justice Gerton Riley was the judge appointed to mediate for the parties. There were 5 issues that the parties could not resolve. She agreed, if the parties agreed, to resolve the issues by having the parties advise her what the issues are, each be allowed to make submission on the issues, and she would decide those issues to save the parties 3 weeks of trial. And she did so. So there, I've had appraisers come to the mediations with the judges. The judges have had access to the coaches and mediators that the parties may have used on the parenting issues to assist the judge in assisting the parties to agree on a parenting plan. So it is a good resource in the appropriate case to utilize. It's one of the processes I have in my toolbox as well that has been used. Sometimes people just have to hear from a judge, judges have said that if you should be scared to go to trial if you have another judge hear your case and give a different answer. So that certainty is very important, and that's why trials in courts are the form of last resort.
Mm-hmm. So even maybe for parties who have maybe been through the collaborative law process or mediation and they've been unsuccessful, JDR might still be a good option, it sounds like.
Yeah, that is correct.
Okay. Okay. I don't think we have any other questions here. If anybody does have any questions or needs any further resources, I encourage everybody to take a look at CLEA's website. We have a lot of great publications, videos, past webinars, and a lot of other good resources on there on many topics of law, not just family law, but everything that you can think of. We also do have our law phone-in and lawyer referral program that I want to flag to everyone. So the way that that works is we have an email address and we also have a phone line. And if anyone has a legal question or needs some legal information, or you're just not sure where to turn or what resources are available to you, that is a great program. So I encourage you to reach out and you can speak to one of our lawyers for free. The contact information for all of that is on our website. And with that being said, I would like to say a big thank you to Norm once again for being here today and for sharing his expertise and speaking to all of us. And that is all. I will let everybody go. Thank you so much for being here once again, and we will see you next time.
Okay, thank you very much.